in the course of your representation of the president, you earned over $9 million, correct?
Yes.
And that doesn't sound fishy to you?
Well, the hypo you just described, I don't think it's appropriate to use the word fishy. It's either ethical or not ethical, and there's
Vermonters would just say it stinks.
That's true.
I mean, that is your signature.
Yes, that is my signature.
Look, you're at the top of the pile here. She was not there. Her 11-year-old son was there alone. And fortunately, at the very last minute, that access to her house or the trip to her house was canceled.
That's not true.
July 15th, 2026, Washington, D.C., the Senate Judiciary Committee. Todd Blanche appeared before the committee seeking confirmation as Attorney General of the United States. Before joining the Department of Justice, he had spent nearly 2 years representing Donald Trump in criminal court. During that time, he earned more than $9 million in legal fees. Senator Peter Welch was not questioning Blanche's past work as a defense attorney. He was asking a different question. Could that past influence the decisions of the nation's top law enforcement official? What began as a hypothetical quickly became a direct examination of ethics, conflicts of interest, and public trust.
Thank you very much, Mr. Chairman. Thank you very much, Deputy Attorney General. I want to talk to you a little bit about the Anti-Weaponization Fund. Just by way of background, you've had a long-standing relationship, of course, with President Trump, served as his personal criminal attorney, right?
I met him for the first time a couple years ago.
Right. And in the course of your representation of the president, you earned over $9 million, correct?
Well, my law firm was paid that much. I had 6 or 7 lawyers.
Well, that was in your financial disclosures. I don't have a problem.
Oh, no, I did. I was paid it. Sorry, but I'm saying it went to my law firm. I had employees.
Right. It's been raised that you have a close relationship with the president, but you're entitled to that, and the president is entitled to appoint as Attorney General a person in whom he has some trust. So that's not an issue for me. But on the Anti-Weaponization Fund, there is the question of whether a president who is suing the taxpayers, the IRS, for $10 billion, and where his formerly personal lawyer is representing the taxpayers, is there a conflict of interest? And my understanding is that before you actually got here, you did get ethics training when you were, after you were acting Deputy Attorney General, correct?
Yes.
And my understanding is that you were advised that you should not be engaged in matters that affected President Trump in his individual capacity. Is that correct?
No, I'm not sure what your understanding is based upon, but no. There's very clear ethics rules that I was required to follow that I do follow.
It's based on a letter from Mr. Terrell, and you received normal ethics training.
Yes.
And normal ethics includes that you do not represent someone with whom you have been representing them before in a personal matter, right?
I'm not trying to get uber technical, but there are very technical rules around the ethics requirements, and I follow them.
All right. Well, maybe you could provide us with what the ethical materials
I can tell you right now if you're interested.
What I'd like you to do is send us the materials. Let me go on. If you had an issue, there was a dispute involving, say, Paramount, would you have a lawyer from the Justice Department who owned $9 million in stock negotiate on behalf of the government with that company?
It depends on as long as there's an ethical and no reason there was no conflict.
So if I had $9 million in stock with Paramount, I'm representing the people. There's an adverse relationship, adversarial relationship. You'd let me negotiate on behalf of the people when the outcome of those negotiations would have an impact on my stock price?
So I just want to understand your hypo. If a lawyer for the Department of Justice has $9 million in Paramount stock, they should not be on that case.
Right.
I agree. Yes.
Okay. And, you know, what happened here with the president that's so mystifying to many of us, it would be analogous if the governor of Vermont sued the Department of Taxes for $10 billion. And we don't appoint attorney generals, but in New Hampshire they do, but let's say we did. And the governor is formerly personal attorney.
There's no comparison
Let me finish my question. the governor sues the Department of Taxes for $10 billion. His former personal attorney, who's now appointed Attorney General, negotiates with the Department of Taxes and ends up settling by setting up a fund in the control, essentially, of the governor for $1.776 billion. That doesn't sound fishy to you?
Well, the hypo you just described, I don't think it's appropriate to use the word fishy. It's either ethical or not ethical, and there's
you know
no.
what? Vermonters would just say it stinks. I mean, that is truly bizarre that the chief executive gets his appointed person, who was formerly his personal attorney, to negotiate on his behalf, where at the end of the day, taxpayers are going to pay. So I'll just leave it at that.
The other thing I'll correct, though, is you use the word as if I negotiated. I wasn't part of the negotiation, which I've said before.
Your department is. You had to sign
Yes,
off on it.
that's true.
That is your signature.
Yes, that is my
So
signature.
I mean, look, you're at the top of the pile here. So
Yes.
you don't get involved in all the phone calls and all the details. But at the end of the day, you have to do due diligence and satisfy yourself that you in good faith can sign off on the agreement.
Correct.
And you did. So
Yes.
that is your responsibility, and I'm sure you accept.
Oh, I do have responsibility for it.
That's
I agree
right.
with that. Yes.
All right.
Blanche agreed with the general principle. A lawyer with a $9 million financial interest should not participate in a case connected to that interest. But he rejected the argument that the same principle applied to his own situation. One fact, however, was no longer in dispute. The signature on the settlement agreement was his.
All right. And, you know, let's talk about the pardons. I understand the president, any president, has total authority to pardon anyone he or she wants. And that includes commuting sentences and it includes restoration of gun rights. You know who Liz Oyer is,
Yes.
and you know who Mel Gibson is.
Yes.
All right, Mel Gibson was convicted of domestic violence. What he did was he punched his then girlfriend in the teeth, threatened her with a gun, while she had their infant in her arms. Now, it's the president's decision. He can restore Mr. Gibson's gun rights. That's not your decision. But my understanding is you had a pardon attorney who, when requests were made to restore gun rights to domestic abusers, they'd be vetted. Mental health issues, other issues, and that's because 500% increase in homicide rates of domestic abusers who have guns. You asked, or one of your people asked, Liz Oyer, to provide a letter that basically said, okay, we can restore his gun rights. Is that correct?
That happened the day I was starting. I know
was
Ms.
2
Oyer
days.
has claimed
It was 2 days after.
I know that Ms. Oyer has claimed that had anything to do with her firing. I didn't even know of that. I had known nothing about Mel Gibson or that letter when I fired her. Nothing.
So why did you fire her?
For a number of reasons. For one,
You were there 2 days?
yes, for a number of reasons. It had nothing to do with Mel Gibson. The decisions that she had made as pardon attorney in the weeks and months leading up to the end of President Biden's term were completely inconsistent with President Trump's authority, including recommending commuting every single individual on death row, which even President Biden didn't do.
Right. I'll let the Americans be the jury of whether that sounds right. But 2 days after
It
you
is
were
right.
there, she got fired. She was told to do a letter that was basically going to validate the decision the president had made to restore gun rights to a man who smashed his girlfriend's mouth, threatened her with a gun, and did it with her holding their infant.
And had nothing to do with why she was fired, by the way. Nothing.
Now,
Blanche insisted that the letter involving Mel Gibson had nothing to do with Liz Oyer's dismissal. He argued that the decision was based on actions she had taken during the previous administration. Senator Welch was not satisfied with that explanation. He turned to another incident, one that unfolded only hours before Oyer was scheduled to testify before Congress.
what also is documented is that she was going to testify here in Congress before a roundtable. And people were dispatched, federal marshals, to go to her home at night. It turns out she was not there. Her 11-year-old son was there alone. And fortunately, at the very last minute, that access to her house, or that the trip to her house, was canceled.
That's not true. I mean, if you want me to answer with the truth, I can.
What part of it is not true?
When we learned that she was going to testify about privileged communications, like we do anytime a former employee is going to violate their ethical duties, we drafted a letter. We tried to serve that letter on her via email. We tried to contact her. She would not answer her phone. Okay. So the way the Department of Justice serves people in every case is with Deputy United States Marshals. We endeavored to do that, and then she accepted service.
Oh, thank you. I'll go on.
By the end of the hearing, Senator Welch had placed 3 separate issues into the public record. First, a conflict of interest standard that Blanche accepted in principle, but argued did not apply to his own role. Second, the dismissal of Liz Oyer, a decision Blanche maintained was unrelated to the recommendation involving Mel Gibson. And finally, the attempted service of a former Justice Department attorney on the eve of congressional testimony, an event both sides described very differently. The hearing ended. The questions did not. Every exchange in this hearing is part of the public record. We'll continue examining what happened inside these hearings, one record at a time.